Reprise de débat, the honourable member for Beaches East York.
Thanks, Mr. Speaker. Two things off the hop. I'll be sharing my time with the member for Mission Matsqui Abbotsford, and I just want to say thank you to my neighbours in Beaches East York. Trust is everything in our democracy, Mr. Speaker. It means a lot to have your trust, and I'm going to work hard to earn it. Now, against the economic threat posed by President Trump, Canadian politicians have rightly renewed calls for building up our country. I'm one of them. It is a nation-building moment. A strong and resilient domestic economy is a priority. Of course it should be. And to that end, we should remove unreasonable barriers to economic growth. If a rule doesn't contribute to the public interest, or if its negative cost is disproportionate to any positive contribution, we should do away with it. But that doesn't mean we should pursue economic growth no matter the cost. Depending on the project, there may be competing public interest considerations: biodiversity and habitat protection, Indigenous rights, climate change, long-term cost effectiveness, democratic participation, and more. Yet, under the guise of responding to the threat posed by Trump, we are sacrificing other important values. We aren't thinking about unintended consequences, and we are actively undermining our parliamentary democracy. Consider the case of two Bill 5s, Doug Ford's Bill 5 and the federal government's Bill C-5. Ontario's Bill 5 became law last week. It gutted habitat protection just to start, but it also enacted the Special Economic Zones Act to give the government unnecessarily and disproportionately unchecked power. Effectively, the government can now designate special economic zones and then exempt or alter any provincial or municipal law that would apply to a company or project within those zones. EcoJustice rightly called it a threat to democracy. Worse. The Ford government shut down democratic debate, curtailed committee scrutiny, and jammed the bill through the legislature. Now, okay, par for the course for Doug Ford, maybe. Fair. But EcoJustice has also called the federal government's Bill C-5 a threat to democracy. And no Liberal government should welcome that accusation. Worse, in Bill C-5, in Bill 5 deja vu, this federal government is proposing to shut down democratic debate, curtail committee scrutiny, and jam the bill through the legislature. It would all actually make Harper blush. Liberals would rightly scream, that we would scream if a federal conservative government attempted the same. Now, okay, fairly, while they share similar goals, and yes, they suffer some similar defects, the federal Bill C-5 isn't exactly the same as Ford's. I mean, Part 1 of our legislation, the Free Trade and Labor Mobility Act, it usefully aims to harmonize federal and provincial rules where reasonably possible. The idea is simple: to avoid duplicative regulation of goods, services, and labor where federal and provincial rules are comparable. And yes, of course, the devil is in the details of assessing what comparable means, but it is a welcome move. The problems with Bill C-5 lie in Part 2, the Building Canada Act. Its purpose is clear: to get national interest projects built more quickly. Okay, so far, so good. The proposed law streamlines authorizations at the same time as it emphasizes the importance of climate action and Indigenous rights. It's a huge and positive distinction from Ford's Bill 5. At no point does Ford's bill even mention climate change or the need to consult with affected Indigenous rights holders. But despite its promise, the proposed Building Canada Act has two major faults. First, it gives the government unfettered discretion in designating national interest projects, and second, similar to Ford's Bill 5, it gives the government unchecked power to exclude or alter any law that would otherwise apply to such a project. The Minister of Natural Resources, he set the stage for Bill C-5 in a May 23rd speech, calling for a renewed spirit of building by reframing the national conversation. No more asking, why build? The real question is, how do we get it done? It would be wise, in my view, of the government to take its own advice when it comes to Bill C-5. Rather than defending the why, the idea of the bill, we should refocus our attention on the how we pass it. In other words, we should improve the bill and respect democratic participation as we do so. First, we should welcome greater parliamentary and civil society scrutiny. The government's proposed guillotine motion seeks to limit parliamentary debate at every stage of the bill. More concerning, it will jam all expert and public testimony and all committee scrutiny in less than 2 days. For what? Consider that Parliament isn't currently scheduled to sit between June 20th and September 15th. We are rushing legislation through Parliament under the auspices of an urgent threat, but we aren't willing to put Parliament to work for what, an additional week to get things right? The debate on amendments does not need to be rushed. We could easily extend committee hearings by an additional week, provide resources for the committee to sit every day, and engage in a more thoughtful process to hear from experts, improve the bill, and pass it through the House by Canada Day. Beyond improving the process, we should also fix the substance of Bill C-5. First, Section 5 currently gives the government unfettered discretion to designate national interest projects. There's a list of specified factors at 5 sub 6 that the government may consider, including the interests of Indigenous people, as well as clean growth and meeting Canada's objects with respect to climate change. That's all good. But as currently drafted, the government does not need to consider any or all of these factors. We can and should change that. We could either mandate the government to consider these public interest factors, or we could require that national interest projects not be inconsistent with them. Simply, Parliament should be more prescriptive than including factors as mere examples. Second, Section 22 would empower the government to exclude the operation of any law from a project it has deemed to be in the national interest. Combined with the unfettered power to designate such projects, it effectively does away with Parliament. An easy fix: remove this unnecessary and disproportionate power from the law. The government can always amend regulations as it sees fit, but it should return to this place, the House of Commons, if a law duly passed by this place is to be excluded or altered in any given situation. If there's a rationale for excluding the operation of a particular law, of course, we can move quickly as needed. There are no doubt other possibilities to improve the law. It may well make more sense to limit the unique process to the next 3 years instead of the next 5. We could require that ministerial advice with respect to conditional authorizations be made public. Expert testimony will likely offer other good ideas if we care to listen. For my part, I will support Bill C-5 here at second reading to send it to committee, because it is time to build, and good projects should be built more quickly. I will vote against the government motion that would hinder the work of the parliamentary committee tasked with public hearings and improving the legislation. And I will vote for Bill C-5 at further stages only if it is amended substantively. We don't make laws in this place for one government, for one prime minister. The laws we pass are binding on all future governments of all political stripes. Even a time-limited law like this one establishes a precedent. If passed as it is, Bill C-5 is a dangerous precedent that will enable conservatives to gut environmental protections when they are in power next. President Trump is a threat to our economy. Of that, there is no doubt. My constituents overwhelmingly voted for a government and leader ready to act, to respond to Trump forcefully, and to build up our country thoughtfully, but not at the expense of our democracy, environmental protections, and Indigenous rights. Thank you.
Questions and comments? Question parlementaire. The honourable member for Barrie South Innisfil.
Well, thank you, Mr. Speaker. My first question to the honourable member is if I could post that speech on my Facebook page. I would appreciate that. But in all seriousness, this is a bill that lacks a lot of things and is susceptible to many things, and that is court challenges as a result of the lack of Indigenous consultation within the bill and other parts as well. I'm wondering if the honourable member can speak to the risks as it relates to potential court challenges related to this bill.
The honourable member for Beaches, East York.
Thanks, Mr. Speaker. Of course, he can post anything I say to his Facebook page. His constituents, I think, would welcome most things that I say, at least. The second thing is, and we shouldn't take the duty to consult lightly. Of course, legislation can't oust the duty to consult. That is a constitutional obligation, and courts have well defined it. The bill, and I said there were some good things in this bill, and I support the object of the bill, of course, but on that particular question, the bill does require consultation with affected Indigenous rights holders, not only in designating a project, but also in the implementation of that project.
Question commentaire.
The honourable member for Laurentides-Labelle. Thank you, Mr. Speaker. I've just understood the extent of the message that we've heard, Mr. Speaker. We heard the colleague use the words used by my predecessor last Friday. But what I don't understand is that he voted in favor. So my question is, what does he plan to do with the next stages, and what does he intend to do so that democracy can do its work and not be affected by this closure?
York.
I thought I had been clear in this, but I apologize if I hadn't been. So the vote we just had was to make sure that we shorten the debate on the government motion. It wasn't a vote on the government motion itself. Now, I said I would support this bill at second reading. Of course, I agree with the object of building this country up. Everyone should agree with the object of this bill. So I'll support getting this bill to committee. I'll only support this bill if there are substantive amendments at committee, and I'm not going to support hindering the work of that committee.
Questions and comments? The honourable member for Winnipeg North.
Yes, so thank you, Mr. Speaker. Within the legislation, there's the principles that I ultimately believe were given to every member of Parliament going out of the election. A mandate that says that we want to take down barriers, build a stronger, healthier one economy. A good example of that is the interprovincial trade, Mr. Speaker, and I'm wondering if the member could provide his thoughts on the importance of interprovincial trade and taking down those barriers.
Member for Beaches East York.
It's in all of our interests to remove barriers to interprovincial trade. The challenge, obviously, is it comes at a particular cost to one province in one case and a different province in another case. The federal government's got to show leadership, and through this bill, in Part 1 in particular, we are showing that leadership, and that leadership should be welcome.
Time for one more question. The honourable member for Sandwich Gulf Islands.
Speaker, words cannot express my deep respect for the honourable member for Beaches East York for his courage. I would like to point out to him that the Canadian Cancer Society believes that Part 1 also needs to be amended and that it could lead to a race to the bottom without exemptions for health and environmental standards as they bring down interprovincial barriers. Again, Greens favour bringing down interprovincial barriers and building one Canada economy, but not with a bulldozer pushing it through Parliament.
The honourable member for. Gotta
10 years, Francis.
Beaches East York. Apologize.
I'll be brief and just say, as I said in my speech, the devil is in the details of what comparable means. And I agree, we don't want to see a race to the bottom, but we definitely want to see a removal of interprovincial trade barriers that aren't reasonable and hinder our economy.
Yes, I think we have time for one more question. Briefly, though, very briefly, a 30-second question. The honourable member for Prince George, Peace River, Northern Rockies.
Yeah, I just wanted to ask the member, we've worked together on the former ethics committee. Would you agree that closure motion is more of an autocratic type action, or is it democratic? I think I would ask, just clarify with the Liberal government, is it autocratic in nature or democratic with this action?
A quick response, the honourable member for Beaches East York.
I might ask him the same because he voted for it, but I would just say, look, a closure motion on a government motion, we shouldn't spend unlimited debate on a government motion. I think we're fairly and fully debating the government motion. The vote's what matters on the government motion, and you'll see how I vote.
Statements by members.